Well, hello and welcome to Wadham College, where we're here for our second webinar. I think a number of you will have watched the first, or either streamed or subsequently watched the webinar we did on material contribution. And for those who didn't, I'm Charles Feeney, and on my right is Professor Sandy Steele, Professor of Law and I think the Philosophy of Law here at Wadham College at the University of Oxford. And to my far right, appropriately, is Mr. John De Bono, King's Counsel from Sergeants' Inn in London. We're here to talk on this webinar about the issue of patient fault in contributory negligence. And we're doing so against the background where I think the three of us are agreed is that it's not a very common finding. And I think an important part of our discussion today will be why it's not a common finding, and whether it needs to be a more common finding or there's an argument for it being a more common finding. I started thinking about this when I did a case recently where I was acting for a health trust in circumstances in which a claimant had been nearly killed by the reckless driving of a man in a van who chose to jump a red light, and was taken as an emergency to the hospital. And there were errors in his clinical management there, which were said to be negligent, and indeed, for reasons we'll see in a moment, said to be grossly negligent. And in terms of looking at this case, which ultimately came down to an argument between the reckless driver and the health trust, consideration has to be given under the 1978 Contribution Act as to what are the respective portions of liability, bearing in mind the blameworthiness and the causation of both the parties. And I came across this judgment of Mr. Justice Garnham in a recent case called ZZZ. I think we're going to run out of initials soon in anonymised cases, but this one is ZZZ. And this was a similar case where a driver had caused injury, grievous injury to a claimant through reckless driving, but errors had been made, allegedly, in the emergency department after this accident. Now, on the facts, Mr. Justice Garnham dismissed the claim for contribution, holding that the health trust were not negligent, so that his comments about the degree of apportionment are obiter because apportionment didn't arise. But he did indicate, as I think we can see from the slide, that in these circumstances he would have considered the blameworthiness of the motorist to be much greater than that of the busy nursing staff. And a case where the issue did arise and was adjudicated upon, the Scottish case of Widowson and Liberty Insurance. In that case, the judge, Lady Wise, put 70% on the reckless driver and made two findings of negligence against health boards, each ordering them to pay 15% each. In fairness, in that case, I think the driver had been driving at 80 miles an hour and had crossed over the road, so it was a pretty extreme case of reckless driving. Now, if in either of those cases the reckless driver had been the claimant, then, unless I'm contradicted to my right, on the current state of the law, the claimant would not be liable for any deduction in respect of the damages which would have arisen from the clinical negligence, even if the clinical negligence was shown to be the predominant cause of the injury thereafter. Now, my perception at the time, which may well be wrong, and we may be informed of that soon, but my perception at the time was that this position related back to the position of the courts in terms of clinical negligence being regarded as a novus actus, in other words, a separate event breaking the chain of causation between the original accident and any injury flowing from the clinical negligence. And that's recently been subject to discussion in the case of Jenkinson and Hertfordshire County Council, a very recent decision, where reference was made back to this decision of the House of Lords in 1949 in the case of Hogan and Bentek West Hartley Collieries. And in that case was taken as authority for the concept that clinical negligence, or medical negligence as it was then called, would always break the chain of causation from a traumatic event. In fact, a consequence of the Jenkinson case, I read Hogan, which I hadn't done before, and that's probably going a bit too far in terms of what it decided, because the ratio of the majority of the House of Lords was that the decision was essentially one of fact, that it was in fact an action under the Workmen's Compensation Act for statutory compensation. And the judge at first instance, in a relevant part of the judgment ran to 3 sentences, had found that the operation which had resulted in a man's injury after an initial accident was ill-advised, and the majority in the House of Lords considered that was sufficient to break the chain of causation from the original accident. So the decision didn't actually say in terms that clinical negligence always broke the chain of causation, but it was interpreted that way until 2001, when along came the well-known case of Webb and Barclays Bank and Portsmouth Hospitals NHS Trust. And in that case, the Court of Appeal considered that unless the negligence was gross, it would not break the chain of causation. Now, we're not really here to talk about novus actus in other contexts, but it's probably just relevant to what we need to talk about to reflect on that decision. The essential reason that they reached that conclusion, reflecting the dissenting speech of Lord Reid in the Hogan case, was that the negligence of the hospital, unless gross, would have been reasonably foreseeable to the tortfeasor, and therefore it would only be in circumstances in which there was what they described as a wholly inappropriate response to the treatment that the chain of causation would be broken. So that remained the law, and probably still does. But in Jenkinson and Hertfordshire, Mr. Justice Andrew Baker was persuaded that there was no rule of law to that effect. And this was an appeal against a decision of a district judge who had refused permission to amend pleadings, and has given one of his reasons that there was a rule of law to this effect, which meant the amendment was pointless. And Mr. Justice Andrew Baker said that that was not the case and there was not a rule of law. Having said that, if you read the judgment, his line of thinking or argument is still very much on the reasonable foreseeability of the subsequent clinical negligence from the time of the accident. So it's not clear in practical terms that a different result would be achieved. Just before we talk about this question of the different result you get depending on whether the reckless driver was the claimant or a third party, I think we should, just in the light of the Jenkinson decision, just digress into that, just have a bit of a take on it. I mean, my impression is that it hasn't made a big difference, because it sort of changed the packaging on the argument. It says it's not a rule of law now, but if you go back to the principle of rule of law, you're going to get the same result. But I may be too optimistic in terms of excluding the law from consideration in this type of case. Well, what do you think, Sandy? What's your take on the Jenkinson case?
Well, I think even prior to Jenkinson, there were authorities which suggested that this wasn't a strict rule of law. So I think even in cases like Rahman and Ariarose in the Court of Appeal, and then subsequently in Wright and Cambridge Medical Group, you have statements to the effect that this is a broader inquiry based on fairness in the particular case, that there's no strict rule that always gross negligence or egregious ineptitude will break the chain of causation. So I think that that's a fair reading of the existing authorities. So to that extent, I suspect this doesn't change a huge amount. To my mind, there's more of a case for a rule of law here, perhaps, in that if we think that the basis of the Novus Actus doctrine is that the subsequent tortfeasor is much more culpable, or their conduct is much more abnormal than the original tortfeasor, then that will only be true, at least where the first tortfeasor is negligent, where the subsequent tortfeasor is grossly negligent. So in cases where the subsequent tort is just simple negligence, if that's the logic of the Novus Actus doctrine, then it shouldn't break the chain of causation in cases of simple negligence. So I'd be more sympathetic to the idea that we really should have a rule that gross negligence should be the threshold.
So you would just be tightening up what is the current practice?
Yeah.
Yeah, I was going to ask you, John. I mean, you've done a lot of these cases. You've probably seen gross negligence pleaded on many times.
Well, I was thinking about this before the webinar, and I was struggling to think of any case where I've actually seen gross negligence pleaded as a Novus Actus. I mean, there must be cases. You think of all the inquests where neglect is found, and so that would probably be a case where you could argue gross negligence. But I don't know if in practice there's a huge appetite for arguing it.
Yeah, I've seen a few where it's pleaded, and that's in the case I'm talking about. The tortfeasor, the negligent driver, always wants to get the hospital in the main action. Defendants aren't very keen on the idea of paying out and seeing if they can get the money off someone else. They like to keep everyone in the mix. And so often they have to plead gross negligence, or this decision had to plead gross negligence as a way of making sure that the claimant then brought the hospital into the action. The position tended to be then that once that had happened, they'd sort of achieved their objective and they realised there was going to be an apportionment. And the issue about breaking the chain of causation sort of faded into the background. I'm not aware that there's any case since Webb where a court has actually found that there was gross negligence. I've never seen one so as to break the chain of causation.
But if you're the defendant, for example, of a motor insurer defendant, why would you need to plead gross negligence rather than just bringing contribution proceedings?
Well, because you want the claimant to bring in. You see, the claimant, in the case I was dealing with, it was undoubtedly admitted liability on the part of the reckless driver. Now, so the claimant could just go and quantify against that defendant. Whereas if they pleaded gross negligence and obliged the claimant to bring the hospital into the action, because if the claimant doesn't do that, the claimant runs a big risk that if the judge does find gross negligence, the claimant's going to fall between two stools. So claimants will almost invariably bring in the trust defendant.
In response to a defence.
Yeah, or yes, it would have to be the
alleging it, because the claimant will have cost protection to do so. So the claimant loses nothing by doing that.
Yes, well, what they do suffer is delay, and also, of course, they have two people ganging up on them in quantum then. So there is a bit of a downside for the claimant, but that's why they do it. But to say I'm not aware that in any case, once the defendant has got to the stage of getting the hospital trust in, that the case has proceeded to trial where gross negligence has been found. I think also that judges tend to be more understanding of healthcare when it's an action for contribution. We see that in the ZZ case. I wonder if the same result had been reached on liability, if it had been the claimant who was responsible for his own action suing in respect of that. Anyway, I think what we're saying is that it's in practical terms. I think Sandy, your view is, we'll defer to you on this, that probably as a matter of law, the judgment, Mr. Justice Andrew Baker was correct, but that in practical terms, it won't make a big difference, really.
I think one other thought is that so often you have multiple breaches of duty by different doctors and in different hospitals.
Yeah.
But you don't have any appetite for one hospital blaming another hospital.
Almost not allowed to do it.
Or there's an understanding that they wouldn't do it normally. But even where you have a situation where someone receives medical care from, for example, the Ministry of Defence, and there's not a formal understanding with the NHSR, you still don't see people trying to run these breaks in the chain of causation arguments. So maybe that's another factor why we don't see it so often.
One other quick thought on this was that it seems to me difficult to rationalise the current law on the basis of reasonable foreseeability. I mean, isn't gross negligence pretty... Well, it's not a far-fetched possibility, is it?
And I was thinking about this just walking over today. I thought, well, when people run people over on pedestrian crossings, I don't think they're thinking very hard about how competent the doctors are going to treat the person when they run them over, really.
Is it a far-fetched... Is it more than a far-fetched possibility that when one negligently runs someone over, that they could be treated with gross negligence? Is that more than... a mere possibility, as they put it in some of the cases?
Well, it also raises the question of what is gross negligence?
Or what is novus actus? I mean, what is so unforeseeable? I mean, how often is the chain of causation broken now?
But when we're doing a run-of-the-mill clinical negligence claim, we might be horrified by what's happened, but we still wouldn't normally talk about it in terms of gross negligence. We just say, well, there's a clear breach of duty here.
Yeah.
I don't know where the threshold would be for gross negligence. I think it's something that's more considered in the coronial jurisdiction because there's an argument about whether there should be a finding of neglect. But within civil liability, I think what one expert might say was grossly negligent, another might say, well, I've seen that plenty of times. It wasn't acceptable, but it's not grossly negligent. So the problem with this could be, if it starts being applied too much in practice, that you just end up with degrees of negligence, and it just makes everything much more complicated.
Unnecessary gloss would be your point.
Yes.
And a good one. Let's come out of that digression and go back to this question, interesting question. Now, so what we're talking about here is a situation in which we've got two identical factual scenarios. In terms of a reckless driving causing severe injury and a claim against a hospital. And the only difference is in accident 1, the reckless driver is the claimant, and in accident 2, it's a third party. So the issue then would be, well, why should we get what appears to be a different result? Now, I think it's helpful to look at the statutory provisions. That's section 1.1 of the Contribution Act, the 1978 Act, Civil Liability Contribution Act, 1978. And the threshold, which is in 1.1, if we go back to look at that, is liability in respect of damage suffered by another person. And then the assessment of contribution is under section 2.1. It's just and equitable. So that would govern, that's the statutory provision, which would govern the apportionment between the third-party reckless driver and the hospital. Now, if the driver in question was the claimant, the relevant statutory provision would be under the Law Reform Contributory Negligence Act 1945, and you can see, or I think, that the wording of that's really very similar in terms of it talks about a person suffering damage, two people being at fault, and then the assessment is, the words I think are identical there, to such extent as the court thinks just and reasonable, having regard to the claimant sharing the responsibility for the damage. So why do you get a different result? Well, I suppose question one is, do we agree you get a different result? Andy?
Well, I think there isn't a direct authority saying you do definitely get a different result, but so we need two conditions to be satisfied for there to be a reduction under the 1945 Act. So one condition is that the claimant has to have failed to take reasonable care for their own safety, and in the reckless driver example, that's clearly true. Not to mention the danger they've imposed on others, of course. The second condition is that fault has to causally contribute to their damage, and this seems to be the key problem. So in some other cases, like the St George and Home Office case, a case about someone who became addicted to drugs when he was a teenager and was negligently placed in the top bunk in his prison cell, despite having warned the prison that when he goes into withdrawal that he might have an epileptic seizure. And so he falls out of his prison bed and suffers serious injuries. And the issue is raised as whether his damages should be reduced for contributory negligence based upon his drug addiction incurred when he was a teenager. And the Court of Appeal rejects this argument, and in doing so draws an analogy to the medical context, but giving examples like liver damage due to alcoholism, that in this context, although that might be classified as fault, and indeed they were willing to classify the addiction in this case as fault, a failure to take care for one's own safety, that it wasn't causally potent to justify a reduction in damages. So I think the problem is the second condition in this context. And part of the rationale that was given in the St George's case was that the doctor's undertaking, or that the purpose of the duty of care in these cases is to protect the person from the pre-existing risk that they face, and that there's something problematic about a reduction for contributory negligence in certain cases where the purpose of the duty is to protect from some pre-existing risk source.
Can I ask a question, Sandy? I understand that applies where the claimant's negligence or behaviour predates, or is an antecedent circumstance. Would it apply if the patient behaved in a reckless way simultaneously with the breach of duty? So, for example, I'm in hospital and the doctor is taking a history from me negligently, but I'm providing incorrect information because I just want to be difficult. And what about afterwards, if I'm treated in a certain way and I'm given instructions and I can't be bothered to follow those instructions?
Right. So I agree that it's clearly not excluded as a matter of law that that one can have a reduction for contributory negligence in the medical negligence context. So, although I think there is only one reported decision which awards such a reduction, this is the Pigeon case.
That was the cervical cancer screening case.
Yep.
And that was what, failing to attend appointments, was it?
Yes.
Yeah, the claimant had been sent lots of letters saying you need to attend, and she didn't, and then she got cancer, and she was critical, and she succeeded in a claim against the GP for failing to ensure that she was screened, but she had contributed to that failure, so there was a reduction of 70%, I think.
And that's characterised as a concurrent negligence then, isn't it? Because that was occurring at the time she was suffering the injury. It wasn't antecedent as with the reckless driver.
And there the risk relates specifically. So the risk that the claimant is taking is a risk specifically in relation to the treatment, that by failing to attend the appointment, one increases the risk of an absence of diagnosis or a misdiagnosis. So the risk that one is carelessly running in that type of case is a risk which is specific to the treatment. Whereas I don't think we would normally say that, in recklessly driving, for instance, that one of the risks that one is running relates to one's subsequent medical treatment. The reason why one is not taking reasonable care for one's own safety in driving recklessly is not because of the future possibility of being negligently treated in hospital.
Just going back to the Pigeon example, I wonder whether there could have been a reduction in circumstances where, having been diagnosed with cancer, she's then negligently treated for the cancer. The hospital, I don't think, would have been able to argue that, well, it's partly her fault that she's got cancer, and therefore we're not liable for having mistreated it, because that would be a situation akin to the St George's case, where her failure or her contribution to her own reaching the stage where she had cancer that needed to be treated might have been the result of negligence, but it wasn't operative or it wasn't a basis for a finding of contributory negligence.
Well, that must be right, because when you think of like lung cancer cases, they're all down to smoking, aren't they? A lot of pathology is down to obesity and alcohol. I mean, if one was going to make that a defence, then every case would have probably some form of defence in it.
Yes.
I was wondering, just to look at the statutory provision. I mean, is the answer here really that the damage here, that there isn't actually a contribution to the damage by the claimant in this situation, where the claimant's negligence predates the negligence of the hospital or the doctor? The damage here is characterised by what happens as a result of the negligence of the doctor and the hospital, because the doctor and the hospital can't be liable for any injury which was untreatable. If the person was always going to suffer a degree of injury and disability, that can't form subject to the clinical negligence case. So it's perhaps the idea here that we're looking at the term damage in a quite a sort of specific way in this context.
Well, I'm not sure. I can see the attraction of it, but if you had two tortfeasors, supposing you were treated after your road accident at two different hospitals, they're both contributing to the damage, aren't they? So what's the difference between those two different hospitals or two sets of doctors contributing to the damage and you contributing to the damage by driving too fast?
Well, because the damage has occurred by the time the hospitals mistreat you, hasn't it?
Well, some damage has occurred, but their failure to treat you makes the damage worse.
Yeah.
And so in the case against the doctor, the damage is constituted by the difference between the patient's current condition and the position that they ought to be in had there been no breach, so whatever that difference amounts to. And you might say, well, the original in the original tortfeasor is responsible also for that damage. If there's no novus actus, then we might say, yeah, they're both responsible vis-a-vis that damage. That seems to be the effect of saying there's no novus actus in such a case.
Yes, I think you would characterise the damage as having been contributed to by multiple factors. You've got my driving too fast, the first doctor failing to treat me, the second doctor failing to treat me. It's all contributed to the damage. But my driving too fast is irrelevant in terms of contributory negligence. There can't be a reduction, as whether there's a formal rule of law or not. And then there's the question of whether that's right or not.
But it has to have some degree of principle other than you don't do it round here. I mean, there has to be some idea of why you don't do it. Yeah. I mean, I was suggesting to Sandy before when we were discussing. I mean, this seems to come out of if you think the health service came 45. Prior to that time, medical treatment was substantially private in various different ways, and the position in contract is, if someone comes to fix my roof and doesn't do it very well, they can't turn around and say, well, you should have maintained this in the first place. And the liability is assessed in the context of the position at the date you enter into that relationship with the person. And to my mind, you can see echoes of that in this situation here, where however you get to hospital, once you're at hospital, whatever you did is not relevant to something which was avoidable on the part of the hospital. Seems to be the way it works, or is assumed to work.
I mean, presumably, if you go to a private hospital and you have a contract for the provision of medical treatment, and it turns out that your liver damage is due to some prior fault on your part, it just seems absurd to say that there should be a reduction for contributory negligence in a contractual claim. So if we take away the peppercorn of tax that we pay for the NHS and there's no consideration in play, should the result be different?
Well, that's a good question. Should the result be different? And I think that comes into scope when we sort of briefly talked about this, cases where we're not just talking about someone being a bad driver, we're talking about someone taking drugs. Yeah? I'm sure, John, you've seen a lot of cases, septic cases, from people who've injected themselves with drugs, often suffered horrific injuries on the back of that, paralysis. Yeah?
Yes.
And of course, we've got the recent Conjanu case.
So let's talk about the Conjanu case.
Yeah, we need to. Let's talk about it.
So, well, correct me if I'm wrong, but the claimant was convicted of attempting to murder his wife.
Yeah.
And in the course of the attempted murder, which he denied, he had injured his hand. And he denied that he'd injured his hand in the course of committing any crime. He was then treated in hospital for his hand injury negligently. And first time round, the defendant trust defeated the claim on the various bases, including that he had been fundamentally dishonest, but also that it was his own fault that he injured his hand. But Mr. Justice Ritchie, on appeal, overturned that, and as I understand it, said, well, it doesn't really matter how you come to be in the situation where you're in the hospital. You're entitled to be, you're owed a duty of care, and the normal considerations apply.
Yeah, I mean, I think the point about fundamental dishonesty was interesting because I think, I can't remember which way around it was, I think the recorder actually dismissed the claim on fundamental dishonesty on the basis that he had lied about how he came by the injury. And Mr. Justice Ritchie held consistent, I think, with what we've just been discussing, that the fundamental dishonesty had to go to the root of his claim. And his claim was related to how he was treated at hospital. It wasn't related to how he came by the injury. And therefore, although he had been, perhaps understandably in the circumstances, fundamentally dishonest, that did not go to the heart of his claim. And I think the alternative argument, which the defendants cross-appealed on, was that as a matter of public policy, if people get injury from serious criminal acts, they shouldn't be entitled to pursue...
It's an illegality type argument.
An illegality type argument, yeah. Now, it depends what newspaper you read, but I imagine there are quite a lot of people out there who wouldn't be unsympathetic to that argument, yeah, and wouldn't be unsympathetic to people who get septic injuries from drug inhalation, not being able to sue the NHS for what some cases are incredibly large sums of money.
Yes, and some of those hypothetical people
Yes.
might think it was a completely different matter if they crashed their car because they were going a bit too fast
Exactly.
on the motorway, and that wasn't the sort of wrongdoing that was being criticised by the policy. So what we might take from that is that it's just opening an enormous can of worms once you start making moral judgments or having, I suppose, some sort of parallel legal process where you're investigating whether someone's actions were more than just immoral, whether they were criminal. And that's really not a very good thing to be doing in the context of a civil jurisdiction, is it?
Well, save that I don't think you typically do it on a sort of Daily Mail reader basis. I think you'd probably look at the terms of the statute and you'd probably say, well, has the claimant actually been at fault? Well, someone who drives 80 miles an hour has been at fault. Someone who injects themselves illegally with drugs is at fault. Someone who tries to murder their wife's at fault.
We might want to separate out this sort of illegality argument from which is perhaps specific to Kojanu and the contributory negligence argument. So on the illegality point, it's perfectly possible to plead that claim without reference to the underlying illegality. That the doctor's duty arises by virtue of their undertaking. You can establish negligence, causation, damage, all of that without reference to the way in which the injury, why this person comes to hospital in the first place. So it's difficult to see how you would satisfy the current defence of illegality under Patel and Mirza, that this would introduce an inconsistency into the legal system by allowing the person to bring a claim in these circumstances, because there doesn't really seem to be any necessary inconsistency between allowing you to bring the civil claim in this context and on the one hand convicting you of the criminal offence which brought you to hospital. But on the fault point, I mean, we've sort of briefly touched on this, but I think there is a danger about analogizing between the rules that we apply to tortfeasors and the rules that we apply to claimants in the context of contributory negligence. It's not obvious, for instance, that all of the rules about, so when we're assessing breach in the context of establishing a claim, the default rule is that we apply an objective approach. It's the reasonable person, idiosyncrasies and personal characteristics are not relevant. It's not entirely clear that that's going to be true at the when we're looking at contributory negligence. And we might say in the context of contributory negligence, there's an argument that you ought to take your victim as you find them, and that we've established that you're a wrongdoer, and so there's more of a case for a more subjectivized approach of the context of contributory negligence. So we might say there's no deep reason for adopting a symmetrical approach between the rules applicable to tortfeasors and the rules applicable to claimants in the context of contributory negligence. And in this context, you might say, I might have a drug addiction or whatever, but I'm not breaching a legal obligation I owe to someone else necessarily by doing those things. And in the absence of breaching an obligation to someone else, that might give us a reason for not applying similar rules in that context.
Well, and if you go down the route of putting too much weight on antecedent behaviour, then are you saying that anyone who's in prison has no right for redress for substandard medical care? And that would obviously go against the principle of equivalence.
Yeah, I can see that. Again, it would be very attractive to readers of certain newspaper. Okay, so now I'm just interested in this idea of this distinction between how you evaluate a claimant's potential fault and that of a third-party tortfeasor. And you were suggesting there is a sort of qualitative difference in terms of how objective stroke subjective it might be. Yeah, I just wonder if you could expand on that, because I think that may be very relevant to what we're talking about now.
Well, I think there are two central differences between the exercise, or as a matter of principle, between thinking about claimant fault and defendant fault. So one is that it's quite frequently the case that the claimant isn't breaching a legal obligation that they owe to someone else. So we might say, we're making a reduction for their fault, but the fault isn't constituted by the breach of an obligation owed to someone else. So they're not a wrongdoer in the true sense. So that might make us more sympathetic in thinking about whether you've failed to take reasonable care for your own safety, because we're not talking about an obligation that you actually owe to another person. And the second reason, which is connected, is that at the stage where we're thinking about contributory negligence, we're thinking about a situation where the defendant is a wrongdoer, and they're, in other parts of the law, we think wrongdoers have to take their victims as they find them to some extent. And again, that might be a reason for adopting an asymmetrical approach between defendant fault and claimant fault. There are other contexts where the law adopts or departs from the usual rigorously objective approach to assessing fault, which bears some resemblance to the claimant's position in contributory negligence. So this is quite a distant analogy, but if a fire starts on my land through no fault of my own, so I'm presented with some risk which I did not create, I have a duty to take reasonable care to do something about it. But unusually, in assessing whether I breach that duty of care, the law adopts quite a subjective approach. It starts looking at things like my personal resources, my mental and physical ability in ways which it doesn't normally do. And the rationale is, or seems to be, that I'm being required to do something in relation to a risk which wasn't of my own creation. And there's a sense in which the victim of a tort, who's then being required to take some steps to either mitigate their loss or, prior to the tort occurring, to take reasonable care for their own safety, is dealing with risks which aren't of their own creation. And so you might say there's some support, indirect support from that legal context to this one.
So the claimant isn't really a wrongdoer at that stage in terms of the risk to their own safety.
Yeah.
You don't become a wrongdoer, and so the concept of fault, which is in the Act, wouldn't necessarily be applicable in that context in terms of the statutory interpretation. I'm trying hard to get it within the terms of the Act. I hope you notice.
Well, I think fault, for the purposes of the Act, does include failure to take reasonable care for one's own safety, which doesn't necessarily amount to legal wrong against others. And of course, there will be lots of cases like the reckless driving case that we talked about earlier, where the claimant's fault is coextensive with a breach of a duty owed to someone else, and perhaps in that context, there's less room for this type of argument.
Yeah. Okay, well, that's interesting. It's a sort of subtext or a substrata to this sort of argument, isn't it? Just to sort of sum this up then, where we've got to, I was talking in terms of antecedent negligence, which seems to be irrelevant to what once you've got to hospital, with cases where the negligence is concurrent. But I think, reflecting on it, I think we're getting to a point where perhaps that's not actually the dividing line. It's really a question of how close the negligence of the claimant is. If it's in an accident, is it actually the background? Is it setting the scene for what happened, or does it have some causal relevance to what happened in the hospital? And I think that, like the pigeon case, may well be an example. I don't know the facts of the case in enough detail. May well be a case where actually the contributory negligence was justified on the basis that actually the claimant's own negligence affected the damage which was caused also by the doctor's negligence. They were part and parcel, both responsible for this damage. I think you've been involved in cases where, John, where similar things have been alleged.
Well, I'm just thinking again about the pigeon case and how we reconcile a failure prior to, or an earlier failure, whether that can be contributory negligence as it was in pigeon, but why isn't it when you have someone driving their car too fast? And I wonder if it comes back to this, but the timing of it, whether there's an overlap between what the claimant is doing wrong and the treatment that is being provided. So if I come back to my example of you're in hospital and you deliberately give the doctor, just for the fun of it, the wrong history, whether makes a contribution to the mistake or to the damage you suffer, and there is contributory negligence there. In the pigeon case, I wonder if there's a distinction between a situation where she had received letters, numerous letters, saying come in for a smear, and had ignored them. So the doctor had engaged with her, and in a way the interaction with the medical profession, which was being criticised, had started. Yeah. I wonder if there's a distinction between that on the one hand and the situation where she hadn't received any letters, and if the defendant had just said, well, women of a certain age should know, as a matter of common sense, that you need to look out for your own health, and therefore that there is cervical screening, and you should go along to the doctor. I think applying the St George's case there, if she hadn't received any letters, she would be in the same position as the drug addict who fell off the bunk. That even if you might say, well, she contributed in some way morally to her situation because she'd made a choice not to be screened, there would be no reduction. But in the actual situation in pigeon, the doctors had engaged with her. The process of, I don't know if the right word is treatment, but interaction with the medical profession had started. And so it was more akin to the situation where it's simultaneous, the claimant's fault and the doctor's fault. And then the clearer example is where you're given instructions by a doctor and then you don't follow them.
Yeah.
Where no one has any difficulty with saying, well, that might be contributorily negligent, providing it was over a certain threshold. I mean, some patients are less capable than others of following instructions. But there might be a question as to whether there was actually contributory negligence. But in principle, there could be, I would think, in that situation, a finding.
So it's a concept of proximity rather than putting
well,
a moment in time.
I've had the word proximity in my head, and I'm conscious that sitting next to proper lawyers, I wouldn't go there, because it might not be the right term.
Well, it's quite a useful term to use if you can't think of anything else.
Well, and some might say that it's been misused by those who, I don't know, let's not go there. But proximity is a dangerous word because it's quite attractive in some ways, but it might mean different things to different people.
I agreed with what you said, John. I just wonder whether would we want to say that it's purely a matter of timing, though? So, if we imagine a case where, suppose I'm visiting a relative in hospital, and I, carelessly slip over a banana skin or whatever, and I'm now being treated by the hospital. It seems to me unlikely there that my failure to take care of my own safety is going to be taken into account in assessing the claim against the doctor, even though there's a very close temporal connection between my conduct and the hospitals. And I think part of the reason for that would be that what makes my conduct careless isn't the risk of some future negligence on the part of the hospital. So even although it's a factual cause, but for my carelessness, this wouldn't have happened. it wasn't within the scope of the risks which made my conduct careless that I might then subsequently be treated negligently by a doctor, and for that reason, it's not. We might say it's not within the scope of contributory.
I understand. So you're talking about scope rather than just timing, or yeah. And I think you're right on that. Supposing if we modify your example and it's the patient who slips on the banana, we're leaving occupiers' liability right out of this. Right. But if the doctor said, don't get out of your bed because you've got low blood pressure, or I've given you a drug which makes you a bit unsteady on your feet, and then you ignore that advice, knowing what you do, and then you slip on the banana, then you might be contributorily negligent because you haven't followed the advice that's been given.
But not contributory negligent in respect of slipping over the banana.
Well, maybe that the answer to that problem is just that the contributory negligence happens afterwards, so it's not an antecedent.
But I've known cases where it was alleged people mobilised too soon.
Yes.
And they said it was their fault that they mobilised too soon. But I'm not sure it was dealt with under contributory negligence. I think it was almost broke the chain of causation if a person gets up and walks around on a fracture and it refractures. I mean, that may be an example of something that shouldn't happen at all.
Well, what would you say, Charles? To take it out of the banana example is not a great one because it does have this occupiers' liability backdrop. But
let's get rid of the banana and proximity.
But if you're involved in a car accident immediately outside of a hospital, and so there's a very close temporal connection between your carelessness for your own safety and then the subsequent treatment.
Well, I think that reinforces the idea it's not temporal and it's not proximate in a physical sense. I mean, why should your liability for contributing negligence depend on how close you were physically to the hospital at the time you had the accident? Yeah.
But isn't that a reason in principle why you should be, it should be possible to make a finding of contributory negligence in respect of an event that happened earlier, like driving too fast?
Well, I think that's a big question. I mean, the question is, what's the justification of excluding that when the person involved, in factual terms, does have a big responsibility for their own safety and also for their own injury, rather? What is the actual justification? And even more so with the man who tries to murder his wife or the drug user. Why should the NHS be paying all that money out? Because they've got to treat him for free anyway, by right. Why should they also now actually have to pay the significantly greater sum of money which he will receive in damages as opposed to what he might get through continuing health care?
I once had a case where my client was run over having been released from prison.
Right.
And then he was negligently treated in hospital. But no one suggested that. So he had a claim against the driver and against the hospital, all because he was leaving prison on that day because he'd robbed a bank 10 years earlier.
Right.
But yeah.
But that's like Sanders' accident outside the hospital, isn't it?
Absolutely.
It's just proximity and time and dangerous concept.
But it was a nice set of facts.
So sort of wrapping this up, I mean, this was a case I found. I was looking for any finding of contributory negligence, and this was a case involving a man who was a diver who got the bends, and he alleged then that there'd been negligence both by the police who came to the scene and by his treatment by the hospital, Newcastle Health Authority. And again, it's obiter because Mr. Justice Stanley Burton dismissed the case against the police and against the Health Trust, but he did say that he would have found contributory negligence. And the contributory negligence in question was that the man attempted, I think because he didn't want it to be known that he developed the bends because it has a lot of implications for your future employment. He tried to solve it himself by what's called in-water compression. And the judge held that would have been negligent. And interesting, because that's actually a man, because he was a diver, who would be attributed to a high degree of knowledge in relation to the wisdom of what he was doing. So it struck me that's quite an extreme case where you've got a man who's got skill and knowledge doing something which was obviously not appropriate. And it did also occur to me as well, and I thought, well, hang on, that's antecedent. Okay, it's only just antecedent, but it is antecedent. But reflecting our discussion today, it was probably right to consider that could be contributory negligence because it was relating to the same sequence of events, this need to have some form of compression after he got the bends. So I think John would probably say it was sufficiently proximate to what ultimately happened to him.
Well, as you've been describing it, I was thinking about the St George's case, and what if the claimant had been injecting himself with an illegal drug in prison while he was on his top bunk, and that had contributed to his epileptic fit and to him falling off the bed? Then you might say, do you think the outcome might have been different in that case? You might say, well, there was I don't want to use the word operative cause, but there was a closer connection between his wrongdoing and what happened to him.
I think so, and precisely because that conduct in the circumstances would substantially increase the probability of this particular accident occurring. Subject at the same time to the point that if the prison authorities' duty is partly to protect him from acts of self-harm, then that might affect how we quantify the reduction that might enter into the discussion of what's just and equitable.
Would there be any difference between that and me driving at 100 miles an hour down Broad Street outside this college and crashing and then being negligently treated in hospital? Well,
I think the difference for me would be that in the driving case, the risk which you're creating is a risk to your own safety by crashing or colliding with others, but the risk isn't a risk in relation to subsequent treatment. So you're not risking your own safety by creating a risk of subsequent negligent medical treatment, whereas in your sort of modified St George's example, this is precisely one of the risks which he's imposing on himself in this example, is the risk of falling out of the bunk by injecting these drugs.
But would there be a difference between him and any other prisoner? So if any other prisoner injected themselves and then were taken to hospital, would they be in that situation capable of open to finding of contributory negligence, or is there something specific about the claimant in St George's that, to do with the scope of duty, for example, that there was a specific worry about him falling out of his bed? Because what I'm still struggling with where we draw the line.
I think we're going to struggle on this, but I think we've got quite close to the line. And I think we're coming to the end of our time. So a lot of time for this webinar, I should say. I'd just like to leave really with this quite interesting thought. I mean, the argument would be if you had more contributory negligence, you're protecting the NHS, yeah? Because you're not making them liable for people's criminal acts, for people's reckless driving. Yeah? And it's quite interesting to see that in the context, isn't it, of how doctors have reacted to similar ideas in terms of patient fault. So I think you recollect there was a period of time during which surgeons were suggesting that they would enter into agreements with people whereby they'd stop smoking or they'd lose weight, and their selection for surgery would be dependent upon honouring those agreements. But in fact, the medical profession, we see a quote there from Professor Alderson, President Royal College in 2018, describing such policies as draconian and discriminatory, singling out specific groups of patients. And similarly, more recently, I'm sure you remember from your reading of the Daily Mail, John, that there was quite a lot of stuff about finding patients who missed GP or hospital appointments, and it was said that the government would impose a £10 fine, and the Prime Minister, that's Mr Sunak, just to be up to date, in October 2022 bowed to pressure from GPs and health leaders, and it was not the right time to take this policy forward. Different context, but what's being said there is actually that's not overall conducive to good health, blaming people for their own part in it. The doctors should get on with treating people however they needed the treatment, which seems to be consistent with what we're saying really about patient fault and contributory negligence.
Well, I'm just thinking of something that Sandy said a little while ago about you take your victim as you find them.
Yep.
And this is a much more benevolent approach and pragmatic in terms of the NHS looks after people as they are. And that seems to work from a legal point of view too.
Well, that's good. I've learned something today, so I hope everyone else who listened to this webinar will as well. So thanks. Thank you.